Our constitution, it is a fundamental duty of every citizen to promote and protect human rights, and we should be constantly aware of this obligation on our part as citizens. When we speak of the state or the state's obligation, we must also realize that there are three key players on behalf of the state: the legislature, the executive, and the judiciary. I am saying this because people have a general tendency to say, yes, it is for the government to do this. Department of Health, Department of Labor, or Department of Education, like that. No, everything starts with the legislation. For protection of and promotion of human rights, the parliament and the state legislatures are expected to make laws in tune with, in conformity with international principles and international commitments. Therefore, protection of human rights, promotion of human rights commences with the legislation by the parliament and the state legislatures. Of course, the basic law is provided in the constitution. Constitution, as I said at the beginning, promotes and protects human rights. It's a constitutional goal, it's a constitutional value. Then it is for the parliament and the state legislatures to make laws, further laws, in conformity with the constitutional provisions and to give effect to the constitutional mandate. In that process, the parliament has made several laws. The state legislatures have made several laws, and whenever any law is made on any subject, the parliamentarians are expected to examine and ensure that it is human rights friendly. The law which they make does not violate the human rights of the citizens or any person. The rules they make, that they approve, do not violate human rights. And then the legislature has also a supervisory duty. The laws which they make are to be implemented, enforced by the executive. Whether the executive is properly implementing the laws is a matter of concern. And the executive is only answerable or accountable to the parliament, to the legislature. If the parliament or the legislature does not examine this aspect, monitor this aspect, take the executive government to task, how can you expect the government to function properly? And therefore, our tendency to keep out legislature from the area of protection of human rights will not be correct, will not be proper. Therefore, the parliamentarians have to be constantly reminded of their duty of discharging their obligation to promote and protect human rights. Naturally, the executive, nobody will doubt. Everybody will agree as the executive has the duty, they have the obligation to protect human rights. Another player in the field of protection of human rights is the judiciary. The judiciary also plays a key role in the protection of human rights. When these laws are enforced or when there is a dispute, it is the Supreme Court, the High Courts and the subordinate courts which have to give effect to the legal provisions. If there is a violation, the violation has to be redressed. Violation has to be prevented. And if somebody violates, he has to be punished for that. Therefore, the judiciary also has to take a pro-human rights approach in deciding cases, in making its awards. So this importance of the judiciary also has to be borne in mind. I am saying this as a general thing. It's not probably connected with today's our program here. But it is necessary to emphasize that protection of human rights is not only the obligation of the state, but also the duty of every citizen. It is equally necessary to emphasize when we say state, we mean all the three key players, namely the legislature, the executive, and the judiciary. And I am saying this for the sake of record, so that it does not go unnoticed. And coming to a National Human Rights Commission itself, it is constituted under the statute, the Protection of Human Rights Act. The preamble of the Act says, this Act is to set up or to constitute a National Human Rights Commission at the national level and State Human Rights Commissions in states for better protection of human rights. This expression must be taken note of. For better protection of human rights. It implies that even without this act, protection of human rights is there, it has to be there. In other words, the parliament says, we have provided in the constitution that human rights must be protected and promoted. But that was in 1950. After so many years, in 1993, the parliament thought that a machinery should be put in place for better protection of human rights. So that is how the National Human Rights Commission and State Human Rights Commissions, and also one more institution is there, that is the Human Rights Courts. They are to be established under the Act. Therefore, I just wanted to remind you that National Human Rights Commission and the State Human Rights Commissions are constituted and are functioning under a statute made by the Parliament. It has the mandate of the Parliament. It has the support of the Constitution, and we are doing it. And we are committed. The National Human Rights Commission is committed to the protection and promotion of human rights. But it is not the 3 members or 5 members sitting in Delhi who can do this job. The Human Rights Commission with its chairman and 4 members, or 300, 400, 500 staff sitting in Delhi cannot effectively protect and promote human rights throughout the country. For that, we want the cooperation of all stakeholders. It is in that context that the NGOs come into the picture. The NGOs, non-governmental organizations. In fact, let me be very frank with you. The NGOs are the eyes and ears of the NHRC and the State Human Rights Commission. It is the NGOs who bring to our notice violations of human rights. It is the NGOs who persuade or help the victims to approach the National Human Rights Commission or the State Human Rights Commission for redressal of their grievance about violation of human rights. It is the NGOs who create awareness among the people about their rights and also about the forum available for them to redress their grievance. And it is in this sense that I said that the NGOs are the ears and the eyes of the Human Rights Commission, and therefore we are natural partners in the endeavor to protect human rights in this country. We are collaborators. It is in this background that the National Human Rights Commission decided to associate with Swasthya Abhiyan, which is a network of NGOs working in the field of healthcare, as I understand. And we thought, through these NGOs who are associated with Swasthya Abhiyan, we will have better reach to the people. We will be able to get better acquainted with realities, ground realities in different regions. It is with this noble purpose that we have associated with Swasthya Abhiyan to organize a public hearing like this. So therefore the main purpose of this program is to acquaint ourselves with the ground realities in different regions relating to healthcare, and also simultaneously to inquire into individual cases of violation of human rights which are brought to our notice. In this context, I would like to respond to some news that has appeared, some publications today. I read it in Times of India. I was told that in some Hindi newspapers also, Marathi newspapers, vernacular newspapers also some news. Therefore, I am bound to respond to whatever observations are made there in these reports. I found that the heading itself is the public hearing by the NHRC is like a Khap Panchayat. What is a Khap Panchayat? The people who wrote the article or who gave the news, they do not have a basic understanding about what a Khap Panchayat is. A Khap Panchayat is something which is unauthorized and illegal. National Human Rights Commission is not an unauthorized body. National Human Rights Commission is not an unconstitutional illegal body. National Human Rights Commission is constituted under a statute made by the Parliament in conformity with the Constitution of India. Therefore, our functions, our inquiries, our recommendations are not unauthorized or illegal like that of a Khap Panchayat. Therefore, the comparison between, they said similar to, this comparison between Khap Panchayat and National Human Rights Commission is totally unwarranted, baseless, wrong. Under the Protection of Human Rights Act, NHRC is authorized to, competent to, inquire into violations of human rights brought to its notice by the victim, by the victim's next of kin or dependents, or anybody on their behalf. Any citizen of this country, any person can bring to the notice of the Human Rights Commission any violation of human rights, and we are authorized by the statute to inquire into such allegations and then make necessary recommendations to the government concerned, maybe to the central government, maybe to the state government. The National Human Rights Commission is also entitled to, competent to, conduct awareness programs. In healthcare itself, we often say prevention is better than cure. If prevention is better than cure in the matter of health, it is equally applicable in the case of other areas also. It is better to prevent violation of human rights than to seek remedies for violation of human rights. And prevention of human rights will be possible only with necessary creation of awareness among the people about their rights, so that the violators as well as the victims will desist from the violations of human rights. So this awareness program is part and parcel of the activities of the National Human Rights Commission. So therefore, if the NHRC is competent to inquire into allegations of violation of human rights, how are we precluded from inquiring into such complaints in different parts of the country instead of sitting in Delhi? If we can do it sitting in Delhi, we can also do it sitting in other parts of the country, so that the victims or the complainants get an opportunity to come to us physically, meet us and present their grievances. Is it not better? Is it not better to the victim in person or the victim's representative in person and listen to them and try to find out, and also the other side, the respondents also, that means the authority is concerned. Otherwise they write in on some papers, we have to look at the purpose and to take the decision. So therefore, it is better to have such inquiries conducted in different parts of the country. Therefore, nobody can object to our going to a particular state or a city to conduct an inquiry instead of sitting in Delhi. Therefore, this criticism has no legal basis, no factual basis, no sense. Then the question is about public hearing. Transparency is the key word today. Everybody is asking for transparency in every walk of life. And when it comes to inquiry into violation of human rights, why do you want to shut out the transparency? Yes, it is public hearing. Let me ask you one thing. Even a case in the Supreme Court, the public can go and see. Even a trial in a magistrate court or in a sessions court, public can go and see. And therefore, when the inquiry is being conducted by the National Human Rights Commission, what is the harm in other people being allowed to come and see and watch? Is transparency a taboo for the National Human Rights Commission? Is transparency a taboo for the NGOs? I am surprised that this criticism is, I don't know the basis of this, but I find some NGOs themselves are behind this news. I don't know whether there is some internal rivalry or something. Jealousy can be one reason, I do not know. Whatever it be. But they should know one thing. They cannot object to transparency in this matter. And it is only a transparent way of doing things that we are having public hearing. Then the one anxiety which I found, problem I found was that they voiced in the reports is that there may be cases which are pending before a court. It's about medical negligence or whatever it be, it is in medical court. So as a matter of policy, as a matter of practice, the State Human Rights Commission does not deal with a case which is pending before a court. If it is brought to our notice that this particular issue is pending before a court for a judicial inquiry and verdict, we take our hands off, we say, all right, you seek remedy in the court, or let us await the decision of the court. And therefore, the apprehension that the inquiry or any finding, any observation or recommendation of the Human Rights Commission may influence the decision of the judicial proceedings has no basis. Has no basis. Because and when a complaint is made to us, we do not know whether it is pending before the court. Only when the other side comes and says, sir, there is a matter, this issue is already pending before the court. Maybe a consumer court, for a high court, maybe Supreme Court, I do not know. Let the other side bring it. Let any side bring it. Whenever it is brought to our notice, we say, all right, if the matter pending before the court, we don't do it. That is the practice. And therefore, the apprehension that we are trying to overreach the judicial process is not correct, is baseless. And let me also tell you one thing. When I should have said it along with that when I said that judiciary has a role to play. I want to make it clear on behalf of the National Human Rights Commission that the Human Rights Commission is not a substitute for judiciary. The Human Rights Commission is not a substitute for judiciary. It is only supplemental. It is only additional. It's an additional forum, it's a supplemental forum. And therefore there cannot be any conflict between the two. And that's why I said whenever the matter is pending before the court, We take our hands off. And even any decision of the commission is subject to judicial scrutiny. Anybody can go to the High Court or Supreme Court challenging the recommendation of the commission. Therefore, let us be very clear about it. The Human Rights Commission is not a substitute or an alternative for judiciary. We are only discharging or playing an additional role or a supplementary role. So nobody need have any apprehension about that aspect. So one more thing I want to make it clear, and because in the light of the report, they said they are mentioning in the report about doctors' negligence, medical negligence. They said doctors' negligence. My dear friends, let us be very clear about it. Doctors' negligence, that is the negligence of an individual doctor resulting in some violation of human rights of a patient, is not the only violation of human rights in the field of health care. There are other forms of violations of human rights in health care. I tell you one thing, there is a district hospital. There is no X-ray machine there in a district hospital. Is it not a violation of human rights of the people who are to be served by the district hospital? There is a X-ray machine, but there is no mechanic. Is it not a violation of human rights? There is a hospital or a primary health center, but there is no medicine. Is it not a violation of human rights? There is a public primary health center, but there is no doctor posted. Is it not a violation of human rights? And therefore, there are umpteen types of violations of human rights in the healthcare system. Apart from the negligence of an individual doctor which resulted in a violation of human rights of a patient. That is only one aspect of it. And even in that case also, if a case is pending before the court, we are not dealing with that. And another thing, the National Human Rights Commission or the State Human Rights Commission has no jurisdiction to deal with a complaint of violation of human rights by a private citizen. We have jurisdiction to deal with complaints of violation of human rights by only the public servants. So if there is any private hospital, private institution, such people also need not worry about this hearing. Whatever it be, let me tell you, by way of conclusion, let me tell you, our idea, our motto is to get better acquainted with the hard realities, ground realities in our country, in the field of healthcare. If we showed some initiative to move from Delhi to different parts of the country to know better the issue, or we opted to seek the help of a network of NGOs who are to be our ears and eyes in this endeavor, are we to be blamed? Instead of appreciating this, people are trying to criticize. Maybe they are well informed. They are not properly informed. They are ill informed. That is why I made use of this opportunity to explain why we are here and what are we for. And I am sure the people who are behind this news will take note of these things. And I think the same media which give publicity to this kind of apprehensions will give the equal amount of publicity to what explanations I have said today here. And that is what is fairness. In all fairness, I expect the media to give the answer which I have given to this people. With these few words, I formally inaugurate this program, and I request all of you to actively participate, and let us make it a grand success. Thank you very much. Jai Hind.